She was walking across the street on 23rd Street in Manhattan when she was hit by a Mack truck. Find out what we had to do when we brought a lawsuit and the truck driver was nowhere to be found. You want to learn what happened? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. She was on her way to work. She was crossing the street at 23rd and 1st Avenue. And now she gets hit by a truck while she's in the crosswalk. We wind up bringing a lawsuit against the truck driver as well as the owner of the truck company. It was a construction company. And now, during the course of the litigation, now I had an opportunity to question the truck driver. I wanted to know a number of things. By the way, there were big signs at that intersection saying "Yield to pedestrians," and we had photographs of it. It was on every single corner, clearly visible. And I relished the opportunity to go ahead and question this driver and show him those photographs. But now, when it was time to question the driver, the defense attorney kept coming back to us saying, "We can't find him." I said, "What do you mean you can't find him?" They said, "We've tried everything possible. We tried to locate his last address. We sent an investigator out to find him. We cannot find him." So what do I do in that instance? Don't I need the driver of the truck in order to prove our case? Don't I need that testimony in order to show that they're wrong and they violated the rules of the road? The answer is no, I don't. So now I had to ask the court for special permission to go ahead and strike the defendant's answer. Now, what does that mean? It means when we start a lawsuit, we go ahead and allege certain things that were done improperly, that the driver was careless and that the driver was not trained properly by his company. And that claim is now answered by what's known as an answer. So the defense attorney has to go ahead and prepare a document called an answer and answer the allegations we have claimed in this case. And that's what they do in every single lawsuit. But now, if they don't produce their driver, I now have the opportunity to go into court and ask the judge to strike their answer. And here's what that really means. It means if they can't produce their driver after a number of attempts, what the court will do, likely, is go ahead and say, yes, the defendant's answer is stricken. And what that means is that all of the allegations that we are making, all of the claims that we are making, basically it's a default. It's like the Yankees show up to play the Mets decide not to show up, the Yankees get an automatic win. Same thing here. It's as if the defense didn't show up, so we will get an automatic win on the issue of liability. When that happens, now we simply go to a trial on damages to evaluate and determine how much compensation my client is entitled to as a result of the defendant's carelessness. So why do I share this great information with you? I share it with you to give you an insight and an understanding to what goes on during the litigation process, especially when the defense doesn't bring in their witness to come in and testify, give pretrial testimony. I realize you're watching this because you have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I answer questions like these every single day and I'd love to talk to you. You can reach me at 516-487-8207. or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.